First item is any opening comments.
Thank you. Good morning. The Special Magistrate will hear all cases on the agenda. The meeting is recorded and televised on the Wellington Government Access Channel 18 on Comcast Cable. Testimony from Wellington staff and the respondent will be under oath. Although formal rules of evidence do not apply, fundamental due process shall be observed. Special Magistrate may ask questions of either party to determine pertinent facts. The Code Compliance Officer will present his or her case to the Special Magistrate. Service of all required notices associated with a case and all photographs presented by the Code Compliance Officer will be entered as evidence unless otherwise disputed. Upon completion of the presentation, the respondent will have an opportunity to comment or cross-examine. The Special Magistrate will issue findings based on the testimony presented. If the Special Magistrate determines there are one or more violations of Wellington's codes of ordinances, he or she may issue an order requiring the respondent to correct those violations by a specific date. The Magistrate may also assess costs that have been incurred in the prosecution of a case. In most cases, costs assessed by the Special Magistrate are due and payable to Wellington within 30 days from the date of this hearing. Failure to remit payment as ordered may result in a lien being filed against the property. In the event the violation is not corrected by the date specified, the order will also provide a date for a fine certification hearing. No additional notice will be presented to the respondents. A lien will be filed against the property if the assessed fines are certified by the Special Magistrate. The Special Magistrate may also issue a cease and desist order. If issued, the respondent is placed on notice that if the same violation reoccurs within 5 years, staff may notify the respondent of a hearing for a repeat violation. At the hearing, staff will request the Special Magistrate assess a fine. The primary object of a hearing is not to unduly penalize anyone, but to obtain compliance with Wellington's codes and ordinances in a timely manner. Cases where the respondents are present will be heard first. When a respondent comes to the podium, please sign in, state your name, and indicate if you have been sworn in. Please ensure all cell phones are turned off or in silent mode at this time. The Special Magistrate will now swear in all persons who will testify.
All right. If you're going to testify this morning, please stand up. If you're testifying, if you have a case, raise your right hand. Do you swear or affirm the testimony you're about to give this morning is the truth and nothing but the truth? Okay. When you do come up, please make sure everybody's cell phone is turned off right now. When you come up to the podium, sign in first and then state your full name for the record. Okay? What's the next item? Any additions or deletions?
No, sir.
Okay. Do we have a consent this morning?
Yes, sir.
Okay. Consent is approved. Next item?
Okay, we have first case where we have a respondent.
Okay. Which case would that be?
The case item number 8 on page 4, under new business.
New business?
Is
Okay.
NOH 18-5334.
Okay.
Clement Golding is the code officer.
What are the, what's the next hearing date? And after that? Oh, okay, that's easy. Make sure I say 2019. Okay. Do we have anybody here on behalf of the village for case number NOH 185334? Is that correct?
Yes, sir.
Is that the case? There we go. Good morning.
What did you say?
I'm sorry to wake you up.
No, I was wide awake. I didn't know it would be called so quickly. You ready?
Okay, we're all set.
Clement Golding, Code Compliance Officer for the Village of Wellington, case number NOH 18-5334. Respondent name is Jeff 1 LLC. The property address 1255 Primrose Lane, Wellington, Florida. This case was established based on a neighborhood improvement inspection. NOH was served by certified mail, return receipt received. Correction date was January 3rd, 2019. An inspection on January 7th, 2019, found the following item remained beyond the time given in the notice, in violation of Wellington Code Land Development Regulation Section 7.3.12.b. Landscape is not maintained, plants and shrubs not trimmed and maintained, and IPMC Section 303.1 and sanitary pool. Wellington Code Sections 36-22B1, roof stained and discolored, 36-22B2, driveway and sidewalk stained and discolored, were both corrected. Photos were taken to represent the condition of the property at the time of the various inspections. A follow-up inspection on January 10th, 2019 found the violations still exist. Staff conducted a pacer search which found that the respondent does not have pending bankruptcy action. Research found there is not a list pendants filed against this property. I made contact with Ms. Fagan, one of the representatives, on November 13, and advised her of the infractions. And on January 7, 2019, I got an email from Mr. Flores with respect to the violations, which I discussed with him, and the corrective measures. He stated that he understands that the case will be going to hearing and will try to bring the property into compliance as soon as possible.
Okay.
The Code Compliance Division
Go ahead.
The Code Compliance Division recommends respondent be found in violation of Wellington Land Development Regulation Section 7.3.12.b and IPMC International Property Maintenance Code Section 303.1. It's recommended that the respondent be given until February 21, 2019 to correct the violations. I'll be charged a fine not to exceed $50 per day per violation for each day the violations continues to exist. It's also recommended that costs incurred by the Code Compliance Division in the amount of $238.24 be assessed in order to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is also requested. In the event the Code Compliance Division is not contacted as required and the violations are not corrected, it is recommended that the fine certification hearing be held before the Special Magistrate on March 21, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida. It's also recommended that no additional notification of the intent to impose a fine be given.
Okay. Let me state this for all cases being heard this morning, that unless there's an objection, all photographs, documents, notices will be admitted into evidence, unless there's an objection. Do we have any photographs in this case?
Yes, sir.
Yeah, we're having a slight problem with the computer. We're working on it now.
Technical
Try to get the
difficulties?
yes, try to get the pictures up.
Okay. Let me ask you this. How do you know, can you explain how you know the pool's unsanitary?
When I went to, from the neighbor's property next door, I could see from the next door neighbor's property. And when I did my follow-up inspection, there was the contractor was there pressure cleaning the roof and the driveway at the time. And I mentioned to him that the pool was dirty if it was there to clean also. He said, yeah, I know it's dirty, I can see it. And he said, yeah, take a look, you know, I'm doing all this work back here. And eventually, not me, but somebody else will be cleaning the pool. Okay. But I could see from the neighbor's property initially.
Well, describe the condition of the pool.
It's green, I mean, really green. As green can be. Can't be any greener than that.
All right.
Really dirty.
So in your opinion, it wasn't being maintained?
No, sir. No, sir. They were, when I spoke to Ms. Flores, and the second time, Ms. Fagan was the first person, and then Mr. Flores the second time. They're aware of it, that it's dirty. The occupant were not maintaining it or not cleaning it.
They acknowledge that?
They acknowledge that,
Okay.
yes, sir.
Okay, sir, you heard his testimony. Can you sign in and then state your full name for the record?
My name is Bruce Desarme.
Excuse me?
Bruce Desarme.
Desarme? How do you spell your last name, sir?
D-E-S-A-R-M-E.
Okay. And your relationship to the owner of the property?
I'm a director of construction.
You're
Director of construction.
director of
Florida.
construction? So you're their contractor, they hired you, or?
No, I'm not a contractor. I hire the contractors.
Okay. So you work for the company or an agent of the company?
Correct.
Okay. So you heard what the issues are this morning in the pending violations. You have anything to add or any defense?
Yes. As he knows, the property was a rental property. The
Right.
previous renters were not taking care of the issue. Once the previous renters had left the property, apparently there was vandalism to the property. That's why the pump was not working to the pool and everything to that effect. We've had to get a couple of quotes to get that issue resolved. We've gotten the quotes. We just actually got one that was viable, and we just signed the contract with that, and they're taking care of that right now. So everything else that you've stated as you were there, we've tended to quickly. We've repaired all the other issues except the pool issue, which was an issue with the vandalism. Had the pump been functioning, we would have gotten that service right away.
Okay, so the roof is no longer stained and discolored
No.
as of today?
Yes, sir.
When was that taken care of?
Oh, that was correct. Sorry to interrupt, sir. That was correct. The roof
Okay.
and the driveway and sidewalk have been
All
remedied.
of it, yes, all have been
Okay.
corrected.
Those have been-
And what about the landscape?
Landscape.
No, sir. The landscaping and the pool are the two issues that remain.
So, okay,
We just had the landscaping just done just this week also,
what day?
as of Monday.
Were you out there since Monday?
This month, no, sir. I wouldn't. No, sir.
Okay, he's saying it was, okay,
Yeah.
Okay. We finally have the pictures up, Magistrate.
okay.
I have to go one by one.
Yeah, please scroll through them.
Pool
We
is
can
cool.
take a look at them. So, according to your testimony, landscape's been taken care of. Did you notify code enforcement officer that it was taken care of?
I tried to have Miss Flores reach out to you. I'm not sure if she got through with you to the email,
No,
but,
I haven't heard from him since then.
So the
okay.
7th is 10 days ago. Let me see. Okay, so it looks like it's being pressure cleaned. I'm trying to see what the issue is with the landscape. It looks like it's been maintained there. Is that the right property?
Yes, sir. That's the right property. That's the landscape. Keep going. You see the pool? Don't go back.
I have to go back.
Oh, there's a pool. There's a
Okay,
pool.
I see the pool. I understand the pool. We have an acknowledgement as to the pool. What about the landscape?
Keep going back.
He's saying it was taken care of.
No, this was. I haven't been there since he said it was correct.
I understand that. So I'm looking at it here. I don't see any issues with the landscape. So maybe you want to point out what the landscape issue was.
It's on the side of the house
The side of the house?
and the neighbor's side of the property. There it is, over there.
On the other side of the fence?
On the inside and the fence inside, sir.
Okay.
Yes, sir.
So it's just overgrown?
Yes, sir.
Was that area addressed?
Yes.
Okay, and how did you address it?
We've trimmed back the
prongs.
hinges, the bushes towards the fence,
Prongs.
and trimmed some of the palm trees.
Palm
That
fronds,
was,
yeah.
that was what was the concerns, correct?
Yeah, correct.
Yes.
Okay. And when is the pool going to be taken care of? You got the pump working now?
No, we have to go purchase the whole, we have to reconnect the pump and everything now, because again, there was vandalism there.
When did the tenants vacate? Do you know?
It was, to my understanding, December, the end of December.
Yeah, okay,
before
so a
Christmas.
couple of weeks ago.
Right, and, due to the holidays and everything.
I
yes.
understand that. How long is it going to take you to address the pool issue?
I think he said he was giving us till February.
I'm asking you. That's what he's asking for. How much time do you need?
30 days, 30 to 45 days, I think would be, I want to get it up to proper. We could get the pump and everything running, but I would like to get
Is
it
the
a
property
little again.
fenced in? Is it safe?
Yes, the property
Yes,
is
sir.
fenced.
Yes, sir.
fenced?
Yes, sir. Yes, sir.
And there's nobody residing there now?
No, sir.
Is there any health issues with mosquitoes or anything in that pool? I mean, it's winter now, so I don't know.
I wasn't evident at the time of the inspection.
Okay. Let me do this. What's 45 days from now? Our next hearing would be,
It would be
Where we look-
February 7th.
no, this is January, today's the 17th, so 45 days from today is what?
Oh, I'm sorry, March 7th.
March 7th? Okay.
Or if you went through that week and then you could give them
What's it?
until March 3rd.
What's the next week? March 3rd's what, a Monday?
It's a Sunday, but then Clement would be out there on Monday,
On
the 4th.
the 4th.
Right, because you would have technically midnight of.
Well, so the next Monday is the 11th?
The 4th.
No, a week from that is the 11th, March 11th?
Yes.
Okay. Okay, here's what we're gonna do, okay? I'm gonna make the following findings of fact. Respondent was present through their Director of Construction. Code enforcement officer was present based on the photographs, the notices, and other documents and evidence, based on the testimony of the code enforcement officer and the testimony of respondent's representative. I find that the pool is not in compliance. I find them in violation of Wellington International Property Code Section 303.1, Wellington Code Section 3622B1, 3622B2, and
No.
Section 7312B are dismissed. Right?
3622B1 and 2 have been corrected, sir.
Right, they're all
Oh, okay.
dismissed. I'm even dismissing the lawn, okay? Because testimony uncontroverted has been taken care of. I didn't see any major issues or, you know, I'm not gonna go there this morning. Let's see, okay. Okay, so here's what I'm gonna do. I'm gonna give you until March 11th to come into compliance. Thereafter, I'm going to assess a fine for this $50 per day. I'm going to assess costs of $238.24, which must be paid by March 11th of 5-year C and D. And in the event code compliance is not contacted as required or the violation is not corrected, a fine certification hearing will be held before the special magistrate on March 21st, 2019, right here, okay, at 9:00 a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to impose a fine will be given. So the petitioner is responsible for the cost of $238.24 by March 11th. You have to come into compliance, take care of that pool, whatever it takes, get somebody out there ASAP to fix that pump. You have until March 11th to do that, and then if you don't, there'll be another hearing here on March 21st.
Thank you, Magistrate. Yes.
Okay. Okay, any other questions?
No, sir.
Okay, case dismissed.
Thank you very much, Magistrate.
Not dismissed, next case.
Okay, we move to the fine certification portion of the hearing. It is item number 4. It is NOH 18-3667. Helen Archer is the code officer. So item number 4 on page 5. So it's 18-3667.
Okay.
Good morning. Helen Archer, Code Officer for Wellington, case numbers 18-3667. Respondent's name is Townhomes of Greenview Shore, HOA Incorporated, and A&G Management Services. Property address is at 13644 Yarmouth Court, Wellington, Florida. Hearing date was November 15, 2018. The respondent was ordered to correct the violations of Code Sections 7.3.12.b. Hedges surrounding parking area are dead and dying on or before January 2nd, 2019, or pay a fine not to exceed $25 per day. The order also scheduled a fine certification hearing on January 17th, 2019 if the Code Compliance Division was not contacted as required and or the violations were not corrected. An inspection on January 4th, 2019 found the hedges had been removed but not replaced in violation of Wellington Code Section 7.3.12.b. Photos were taken that represent the condition of the property. Follow-up inspection on January 14th found the violations still exist. Contact with the HOA president and property manager was made throughout this case. The Code Compliance Division recommends the respondent be found in violation of the order of Wellington Section 7.3.12.b, that the respondent be assessed a fine in the amount of $25 per day commencing on January 3rd, 2019, and cost in the amount of $478.48, which includes costs assessed in the order, both continuing to accrue until the violations are corrected.
All right. So basically, what are we talking about? Are we talking about, I guess that picture's showing me dead lawn, and what was
That-
wrong with the hedges?
That was the before picture where the hedges were missing and dead. So I had requested for them to remove the dead ones and replace the missing ones.
Okay, so that's the only issue now?
That was it,
And where do the hedges belong?
around the parking area. It's an HOA area.
Okay. And it's common elements of the HOA, not
Yes,
the
sir.
individual unit owner? Okay.
Mhm.
Yes, sir. You state your full name for the record?
Yeah, Andy Hermida.
Okay. Have you signed in?
I did.
Okay. Mr. Amita, go ahead. You heard what they have to say.
The only thing was, we replaced some hedges along the building. There was a lot of miscommunication. A lot of the emails were, I replaced some hedges. We removed these at the end when I finally got a picture to do it. But when I signed the stipulation, it didn't say anything about replacing them. And I asked whether we could just sod that area, because the parking space is difficult when we have hedges there. but I never got a response back for that question.
Is this the only photograph we have on this? Are there more
There's
photographs?
two, there's another one, there's two, yeah. So
Okay,
Yeah,
and
that
this,
one's the before.
The before,
and
and
which ones are we looking to remove? The one right there?
all of that was removed.
That
All
was
whole
removed.
section was removed. I just
That was
needed-
dead, that was dead, or
There
just
was,
need?
you see that little stumps right there?
Yeah.
On the bottom right there? Those were dead hedges that had been
The,
removed.
the rest of them were dying off as well.
Yeah.
Okay.
But the code says that around the parking area for the parking lot has to be screened. There's a screen area for the parking area. Now, this case started back in, I'm gonna say, yeah, June. So when I spoke to the property manager, which is PJ Rader, she had already been telling me that, I had already told her that the hedges were missing, dead in the parking area. There was no response on August 23rd. I had left messages on August 29th. Went out, no response again from September 5th. They got a green card. It's not like we did not have any type of communication. We could have met at the property. I know he lives there. You live there, right?
I do.
Yeah. So,
Mr. Hermida, what's your position with the association?
The HOA president.
You're the president?
Mhm.
Okay.
yes, and at the time, in October, he said he had replaced the plants, but they were.
Yeah, we apparently replaced the wrong ones. I replaced some along the building.
So they had already known that they needed to be replaced.
But then when I signed the stipulation in November, it didn't say anything about replacing, so I just was following what this said, because it was a lot of back and forth. I left messages on the main voicemail for Code Enforcement. I never got any response back from that one.
That's not true.
It was a lot of back and forth. It's 3 people going back and forth. It's my property manager as well.
Steve, you may want to get with village council on these stipulations, and you may want to add another paragraph as to specifically what needs to be done.
Well, they usually attach, we generally attach
the-
the violation detail.
It does,
from the
I
violation.
highlight, it just says remove dead trees, which is what we did. I didn't know.
The narrative,
It's a lot of,
Missing and
the
dead.
narrative said missing and dead hedges surrounding parking lot, the maintenance is there, all the information on getting a,
It says remove dead trees, which doesn't really apply. You're talking about hedges. Repair and maintain all landscaping.
repair and maintain all landscaping as described. There's a land development regulation, repair and replace, right there. Again, PJ Rader was the one I had been speaking to at the beginning, and she knew exactly what needed to be done. I'm not sure why she didn't tell Andy.
Still, when you sign a stipulation, I mean, you could even put a paragraph in there as per, and reference that section. Because it says repair/replace. I could read that as either or, too. It doesn't say and, you have a slash in there. I don't know if that's exact language from the code. It'd be a lot simpler if I'm signing a stipulation to know exactly what I want to do, and you could say, as per the attached code, and you could put in there, repair and replace as per the attached code. I'm telling Steve to get
I
with
told
council. That would be my recommendation, so there's no misunderstanding, because I can see how things can be misconstrued, and,
I mean, typically, we actually take the violation detail that went out with the notice and we attach that to the stip.
I see that you did that, okay? I'm not saying you didn't. I'm just saying if you just even reference in the stip as per
understand.
the
Okay.
violation,
All right,
or
I'll-
replacing, a little statement as to what people should do
Okay.
in the stipulation. It
I'll-
doesn't hurt to
I'll,
add one more paragraph.
Okay,
And-
I'll bring it up to the village attorney.
You could just say,
Mhm.
that'd be my recommendation. Okay, you know that, so you're here today for a fine certification. They want to assess you a fine of $25 a day since January 3rd for not replacing the hedges. What kind of plan does the association have to replace the hedges?
I mean, if you guys want us to replace it, I'd be happy to replace it. I was just going by what it said here. I didn't know if we could have that area without hedges, but, I mean, we'd have to root ball that out a bit and get some hedges in there. That's the only thing. I mean, I told her as well when we replaced the first ones to give me some time, because I've had a sprinkler company out there 5 times. It's an older electrical system. They just got done fixing that. It took them 5 times to get out there to do it. I replaced my landscaping company. So it was an issue, but you know, I'm trying to get it wrapped up, but it just took a little bit of time.
How many units in your association?
Just 8.
8? Is it 2 buildings?
Mhm.
2 quads? And hedges are just one side or both sides of the driveway, or what are we looking
This
at?
is just one little strip of hedges, that's it. It's
Yeah.
not
It was
a
in
whole
a
lot.
really, it was a really difficult part. It's at the very end of the sprinkler system, and it was the last piece that got repaired. It just took a long time to get it. It's electrical problems. It was,
So you want hedges from the bumper to the street?
To the edge of the driveway
To
there.
the edge of the driveway?
Mhm.
Okay, wherever the grass stops. Can you do that in 30 days?
yeah, we can do it. in 30 days.
I'm gonna continue this case, until, let me get my agenda here. It's at the February 21st?
Yes.
Okay, to come into compliance, okay?
Okay.
So, I'm gonna stay the fine, and if he's in compliance by February 21st, my recommendation, I'm not gonna be the special magistrate at that time, but is to dismiss the case.
Well, we could just grant an extension on the stipulation. That might be the easier way to do it.
Okay, that's fine. That's,
This way, if he comes into compliance, we just dismiss the case.
is that what you're suggesting?
Yes.
Any objection?
No.
Okay, so we'll extend the stipulation to February 21st. If you're in compliance, there won't be any fine, except for the costs. Okay?
Okay.
So you got
That's fine.
a little more than a
Are
month
you
to take care of this.
assessing the cost now?
Wasn't it assessed last time?
It's waived as part of the stipulation.
Your costs were waived?
Right, as part of the stipulation agreement, staff waives the
Okay, I'm not
costs.
gonna assess cost. If he's not in compliance, cost will be assessed on the 21st of February. Okay, so you really have till February 20th. Any questions?
No.
Okay, so the stipulation's extended to the 20, why don't we say the 20th of February?
Okay.
And you'll be back here on the 21st if it's not in compliance. Is that enough time?
No,
How much time you need? How much time between?
because she wanted,
How many days before the 21st do you need to verify?
Just give me 4 days before the 21st. Let's just say, say the 15th,
The-
February 15th?
What's that Monday?
February 15th, and then she got on the 18th.
Okay.
Okay, so what date we want to give them to?
February 15th.
It's just logistics. You have till February 15th,
Okay.
okay? And, otherwise you'll be back here on the 21st. The case will be back here, whether you are or not. Okay?
Okay.
Well, thank you for coming in this morning,
All right, thanks.
okay? All right. Next case?
Okay, next case will be, let's see, item number 5 on the new business on page 4. Actually, I'm mistaken.
Is that 183122?
Sorry, miss, what address are you here for?
That one?
Okay.
Okay.
I have to learn to trust myself. That was it. So it's item number 5 on page 4, NOH 18-3112.
Okay. This is Clements, is he not here? Okay, if we can't find him, we'll have to, here he is. You're up, Mr. Golding.
Clement Golding, Code Compliance Officer at the Village of Wellington. Case number NOH 18-3122. Respondent name is IH5 Property Florida, LP, Invitation Homes. Property address 13591 Brightstone Street, Wellington, Florida. This case was established based on a complaint. A novena wage was served by posted notice on December 19, 2018, at the property and at the Wellington Municipal Complex. Correction date was January 6, 2019. An inspection on January 7, 2019 found the following item remained beyond the time given in the notice in violation of Wellington Land Development Regulation Section 7.3.12.b. Landscape not maintained in neat and orderly condition. Lawn is overrun by weeds. Proposed rotating to represent the condition of the property time the various inspections. Follow-up inspection on January 9th, 2019 found the violation still exists. Basic search conducted by staff found that the respondent does not have pending bankruptcy action, nor is there a list pendants filed against this property. I've had several contacts with the former manager, Ryan. He's no longer with the company. And since then, I spoke to Mary, another representative, several times, and I've granted extensions to hopefully bring the property into compliance. So far, they said they treat it with weeds and with chemicals, as well as they have replaced some sections of it. However, those efforts still fail to completely correct the violation. The Code Compliance Division recommends this respondent be found in violation of Wellington Land Development Regulations Section 7.3.12.b. It's recommended that the respondent be given until February 21, 2019 to correct the violation, or be charged a fine not to exceed $50 per day for each day the violation continues to exist. It's also recommended that costs incurred by the Code Compliance Division in the amount of $386.57 be assessed in order to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is also requested. In the event the Code Compliance Division is not contacted as required and or the violation is not corrected, it is recommended that a fine certification hearing be held before the Special Magistrate on March 21, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida. It's also recommended that no additional notification of the intent to impose a fine be given.
Okay. Is the lawn being mowed, maintained, or is it just,
Yeah, it has been mowed. It's being mowed, sir. It's being mowed.
okay. So the only landscape, I see the weeds, but the only landscape, I mean, the hedges there are maintained, is that one little bush that you're showing me a picture of that has a little couple things sticking up? Is that it?
That is more.
There's more of those? Well, that's the same one. Everything else looks like it's being trimmed. So, well, when they,
If you look all along the swale and in front of that private.
well, the swale is the weeds. I see the weeds. Everybody in Wellington has those weeds. I mean, you mow them and you cut them off and then, but I don't know how you get rid of them.
See where it is, Mr. All the other properties around there, the gentleman across the street, directly across the street, is replacing his. And he was complaining that the weeds are coming from when the wind takes it and it blows it flying across his lawn.
Yeah.
So he's in the process of replacing his as we speak. I was here yesterday.
So let me ask you a question so I understand. Go back to the swell area. See, there's some grass there. Is it like, what percentage would you say is weeds in there? Is it 80%? 100%?
I would say the entire swale is about 85% of the swale is weeds.
Okay. Okay. Have you signed in, ma'am?
Yes, I have.
And your name for the record?
Shantae Hay.
Shantae Hay? Okay, Ms. Hay. And your position with the respondent, the owner?
I'm one of the tenants.
You're a tenant. Okay. Are you authorized to speak for them? Or you're here as a tenant? They asked you to show up?
Yes.
Okay.
Well, from the tenant side, yes.
The tenants want,
Not from
The owner.
Owners, no.
oh, you're here on behalf of the tenants?
Yes.
Okay, what do you have to say?
Nothing. I was just here to listen. Because
I mean,
from-
as a tenant, are you happy with the weeds or?
no, but from my understanding, the owners are supposed to be taking care of the lawn and all that stuff. And the notices have been going to them until we got the one on the garage regarding the lawn.
Right. That's just what they have to do. They post it on the garages of the property owner. And
Right.
it's not,
And they're fully aware of it because I did meet with the landscaper last week at the property and we walk it together. They sent them, the owner did, send them to meet with me so I can walk the property with them. I don't think you were there or not. But they're fully aware of it and they're in the process of getting the bids. It should be done very shortly because I spoke to Mary
okay.
last Thursday.
So you have anything else to add?
No.
No? Okay, well, thank you for showing up. Okay, let's take case number NOH 3122. I make the following findings of fact. Code compliance officer was present. Respondent was not present, but Ms. Hayes as a tenant was present, not representing the respondent, but just representing tenants. Based on the photographs, the notices, and other documents and evidence, I will find them in violation of Section 7.3.12.b. They'll have until February 21st to come into compliance. Thereafter, I'm going to assess a fine of $50 per day, cost of $386.57, 5-year C&D, and in the event the Code Compliance Division is not contacted as required and/or the violations are not corrected, a fine certification hearing shall be held before the Special Magistrate on March 21, 2019 at 9:00 a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to oppose a fine shall be given.
Thank you.
Thank you, Ms. Hayes, for coming out.
Thank
Okay.
you.
You have any other cases, Ms. Golding? Or are you gone?
I'm done, sir.
Okay, we won't look for you. Have a good morning. Next case.
Okay, that concludes all of the respondents, so we will go to the top of the agenda, which will be on page 3. We're going to go to item number 1, which is NOH 18-1345. Todd Gregory is the code officer.
Good morning.
Good morning.
Todd Gregory, Code Officer for the Village of Wellington. Case number 18-1345. Respondent's name is Dale Carter. Property address 12283 Sawgrass Court, Wellington, Florida. This case was established based on a neighborhood improvement inspection. The NOVNOH was served, certified mail return receipt received. Correction date was November 22nd, 2018. An inspection on December 16, 2018 found the following items remain beyond the time given in the notice of violation of Wellington Code Section 62-9C. Commercial vehicle, a white pickup truck with signage parked or stored in a residential neighborhood. Photos were taken to represent the condition of the property at the time of the inspection. Follow-up inspection on January 6, 2019 found the violation still exists. Staff conducted a PACER search which found the respondent does not have a pending bankruptcy action or lis pendens. The Code Compliance Division recommends the respondent be found in violation of Wellington Code Section 62-9C, and it is recommended that the respondent be given until February 21st, 2019 to correct the violation or be charged a fine not to exceed $25 per occurrence for each time the violation is found. It is also recommended that costs incurred in the Code Compliance Division in the amount of $212.26 be assessed in order to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and or the violations are not corrected, it is recommended that a fine certification hearing be held before the Special Magistrate on March 21st, 2019 at 9 a.m. at Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida. It is also recommended that no additional notification of intent to pose a fine be given.
Okay, thank you. I'm going to make following findings of fact. I find that notice was served on the respondent. Respondent was not present. Code Compliance Officer was present based on the testimony of the Code Compliance Officer. And together with the photographs, notices, and other documents that might have been entered, I find that the respondent's in violation of Wellington Code Section 62.9C, commercial vehicle parked on the property. How many times have you seen this? Is it every night, or is
Well, I don't get out there every night because we don't work that much, but at
every
night,
time you're
there has been once that I went there and it wasn't there. I can tell you.
is it usually at night, during the day, or all hours?
Well, it's there at night. It's not there during the day. So when I go by there during the day, it's not there. But every time at night, it's been there.
And when you go by, do you go by once and then come back a couple hours later, or
If it's there.
if it's there, you'll
Well,
make sure?
If it's after 8 o'clock, it's just in violation. I don't have to come back an hour later.
Okay.
Or if it's there on the Sunday.
Have you seen it on the weekends?
Yes.
Okay. All right. I'm gonna give them until, I'm not gonna wait that long, this is a vehicle.
Yeah, I realize I gave
I'm gonna
them
give them until February 1st to come into compliance, which is a Friday. Thereafter, $50 per day, violation cost of $212.26, 5 years C&D, and in the event the Code Compliance Division is not contacted as required, and/or the violation is not corrected, a fine certification hearing will be held before the special magistrate on February 21, 2019, 9:00 a.m., the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to impose a fine shall be given.
Thank you.
Okay.
Okay, next case will be item number 2, NOH 18-1557. John Jarvis is the code officer.
Morning.
Good morning.
John Jarvis, Code Officer with Wellington, case number NOH 18-1557. Respondent's name is Sharon Tawari. Property address is 1256 White Pine Drive, Wellington, Florida. This case was established based on a complaint. The NOH was served by certified mail, return receipt received. Correction date was January 6, 2019. An inspection on January 7, 2019 found the following items remain beyond the time given in the notice. In violation of Wellington Code Section 3622B1, the roof remains in a state of deterioration. Photos were taken that represent the condition of the property at the time of the various inspections. Follow-up inspection on January 15th found the violation still exists. Staff conducted a PACER search which found the respondent does not have pending bankruptcy action, and research found there is not a lis pendens filed against this property. I've had no contact with the owner. On March 2nd, 2018, an incomplete re-roof permit was submitted to the building department, along with a payment for $232.13. However, there's been no action on that permit since.
What date was that?
That was March 2nd, 2018.
Okay.
The Code Compliance Division recommends the respondent be found in violation of Wellington Code Section 3622B1. It is recommended that the respondent be given until February 21st to correct the violation or be charged a fine not to exceed $25 per day for each day the violation continues to exist. It is also recommended that costs incurred by the Code Compliance Division in the amount of $229.58 be assessed in order to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and/or the violation is not corrected, it is recommended that a fine certification hearing be held before the special magistrate on March 21st, 2019 at 9 a.m. at the Wellington Municipal Complex, 12,300 Forest Hill Boulevard, Wellington, Florida. It is also recommended that no additional notification of the intent to impose a fine be given.
Okay, tell me what I'm looking at in these photographs, because I can't tell if that's a different material or if it's just dark and
It's wood shake. Can you zoom in a bit and you can see that they're lifting and there seems to be some patches, perhaps, of metal.
So are these quads, duplex? So this is a single family?
townhomes. They're conjoined. They're
So one has asphalt shingles and this has wood shakes?
Yeah, at one time they were all wood shakes, and that is one of 2 remaining out of the 25 units that is still a wood shake roof.
So the one with asphalt is not related?
Right.
Oh, okay. Then I'm looking at the wrong picture. Okay. And what's wrong with the wood shingles?
Well, they're lifting, they're stained. I mean, they did apply for the permit. I think they understand that they need to be replaced. I believe that's the original roof. So it's got to be 30 years old.
He's got to be at least 30 years old.
30
Yeah,
years
there aren't
old.
very many of them left
No,
Throughout Wellington or in this development?
in Wellington.
Yeah.
in Wellington. And this development, there's about 25 units, and it's one of 2 that are left.
And how's the other one? What condition is it?
It's not as bad, but it's due probably in a couple of months.
Well,
too.
if people maintain them,
Yeah.
they'll last, but people, if they
Well,
don't maintain them.
nothing
this
lasts,
is- Yeah,
but,
this
yeah.
is what we wind up with.
Is there another side to this roof?
No, because it's like, the other side of the roof would be another unit, and that's
Asphalt?
been corrected.
So it's
yeah.
just this one area?
Yeah.
Okay. So pressure cleaning it wouldn't satisfy the village. What this needs to be, it's deteriorating, the defect it needs to be.
Well, they need to have a roofing company go out there and make the right
Well, it's
assessment, if they
maintained.
can
Okay.
repair it or
All right.
if it needs replacement. And then getting to the compliance thing, to give them 30 days to necessarily repair it really isn't probably very, very fair to the respondent. Maybe
No.
30 days to get a roofing assessment as to what needs to be done. Something along those lines.
Well, this has been, well, they filed the permit. When you say it was incomplete permit, the permit was not enough information?
There
or-
was not, certain things that the building department requires to issue the permit were not there. I did have the permitting people reach out to the contractor listing what was required and if they could be of any help, and that did not get a response.
And this is a rental unit, I assume,
It
by
is.
the,
Yes, it's a rental
and
property.
you never heard from the owner?
No.
All right. Case number NOH 1557, I'm going to make the following findings of fact. Find notice was served on the respondent. Respondent was not present. Code compliance officer was present. Based on the testimony of code compliance officer, together with the photographs, notices, and other documents that might have been introduced, I find respondent in violation of 3622B1, a deteriorating roof. They will have until February 21st to come into compliance. Thereafter, a fine of $50 per day, cost of $229.58, 5-year C and D. And in the event Code Compliance Division is not contacted as required and/or the violation is not corrected, a fine certification hearing shall be held before the special magistrate on March 21, 2019 at 9:00 a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to pose a fine shall be given.
Thank you.
Okay, thank you. Mr. Jarvis, off the record, are you a resident, are you a native of Florida?
For the past 29 years, I guess.
Okay, oh, okay. Well, you're the only one here in short sleeves and a pullover shirt, and everybody else is bundled up. I'm thinking, wow.
We work with a bunch of pansies.
Yeah. That was all off the record, guys. Next. Mr. Jarvis, for the record, are you from Canada? That explains it.
All right, next case is item number 3, NOH 182015.
Helen Archer, Village of Wellington, case number is NOH 182015. Respondent's name is Frederick Francois Pexito Gomez de Abreu. Property address is 14082 Wellington Trace, Wellington, Florida. This case was established based on a neighborhood improvement inspection. The NOV-NOH was served by posted notice on December 17, 2018, at the property and at the municipal complex. Correction date was December 27, 2018. Research on January 2, 2019 found no change in an abandoned permit, a violation of Code Section 18-32, 105.4. Staff conducted a PACER search, which found that the respondent does not have a pending bankruptcy action. Staff contact with representative on April 18, 2018. Respondent had sent out a AC company to pull a permit for a AC unit that was not permitted. They pulled the permit, but they failed to continue with it. April 18, 2018, that was on April 18, 2018. The Code Compliance Division recommends the respondent be found in the violation of Code Section 18-32, 105.4. It's recommended that the respondent be given until February 21st, 2019 to correct the violation or be charged a fine not to exceed $25 per day for each day the violation continues to exist. It's also recommended that the cost incurred by the Code Compliance Division in the amount of $306.15 be assessed in order to be paid within the 30 days of the date of this meeting. A cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and/or the violations are not corrected, it's recommended that a fine certification hearing be held before the Special Magistrate on March 21st, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida. It's also recommended that no additional notification of the intent to oppose a fine be given.
Okay, so they pulled a permit for an AC unit?
They failed to pull it. I did an inspection, found that they had not pulled a permit. They sent an AC company out. The AC company pulled the permit and then abandoned it. They never did anything with it.
They pulled the permit,
Yes, they actually applied for it.
and, okay. Was the AC unit replaced?
It was replaced without a permit,
Oh, okay,
correct?
okay. That's, because you have, violation is that the permit expired.
It did expire, yeah,
Really
because they
hadn't.
abandoned it, yeah. They
It
didn't
was
do anything.
abandoned,
Yeah.
okay. Okay, case number NOH 182015, make the following findings of fact. Find notice was served on the respondent. By the way, you never heard from the respondent or other?
No,
Is it owner occupied?
no, it's a quad. Owner lives in Argentina.
Okay. Notice was served on respondent. Respondent was not present. Code compliance officer was present based on the testimony of code compliant officer together with the notices and other documents. I find that the respondent is in violation of Wellington Code Section 1832-105.4, an abandoned permit for an AC unit. They will have until February 21st, 2019 to come into compliance. Thereafter, a fine of $25 per day, cost of $306.15, 5-year C and D, and in the event the Code Compliance Division is not contacted as required and/or the violations are not corrected, a fine certification hearing shall be held before the special magistrate on March 21st, 2019 at 9 o'clock a.m. at the Wellington Municipal Complex, 12300 West Forestdale Boulevard, Wellington, Florida. No additional notification of the intent to pose a fine shall be given.
Thank you.
Okay, next case.
Next case is item number 4 on page 4. It's NOH 18-2911. Lena Bott is the code officer.
Good morning.
Good morning.
Lena Bott, Code Officer for the Village of Wellington. Case number 18-2911. Property owner Edith Eleanor Bennett. Property address 1219 Widgeon Road, Wellington, Florida 33414. The hearing date was October 18, 2018. The special magistrate ordered violations of Wellington Code Section 62-9C commercial vehicle be corrected on or before October 28, 2018, or pay a fine not to exceed $50 per day for each day of noncompliance. The costs in the amount of $389.40 were assessed in order to be paid within 30 days, and a 5-year cease and desist order was put in place. An inspection on December 1, 2018 found Wellington Code Section 62-9C commercial vehicle in violation of the order. Photos were taken that represent the condition of the property at the time of the various inspections. A notice of repeat violation and notice of hearing was mailed on December 5, 2018. The notice of repeat violation, notice of hearing was served by certified mail, return receipt received. Follow-up inspections conducted on December 5, December 27, January 6, January 8, and January 11 found the commercial vehicle remains on site. The staff conducted a PACER search which found the respondent does not have pending bankruptcy action and there is not a list pendants filed against this property. There has been no further contact with the owner. The Code Compliance Division recommends that the special magistrate find that the respondent has violated the order dated October 18, 2018. It is recommended that the respondent be assessed a fine in the amount of $100 per day, commencing on November 20, 2018, for a total of 6 violations, which is $100, times 6 for $600, plus the new cost of $264.06 in the amount of $1,253.46, which includes the unpaid costs, $389.40, assessed in the order dated October 18, 2018. It is also recommended that the cease and desist order be extended for a 5-year period.
So they pay nothing. Is the $50 per day from the October 18th, 2018 order, is that still running?
They had come into compliance at
They
that time.
stopped?
They-
Is
yeah.
it the same, do you know if the records show if it's the same vehicle?
It is the same vehicle.
All right. All right, so we're just asking for continuation. Case number NOH 182911. Make the following findings of facts. Notice was served on respondent. Respondent was not present. Code compliance officer was present. Based on the testimony, code compliance officer, together with the photographs, notices, and other documents and evidence, I find that there is a continuing violation of 62-9C of Wellington Code, commercial vehicle on the property. I'm going to assess a fine of $100 per day for all violations, for each day the violation occurred since, what was it, November 20th, 2018? Okay. I'm going to assess cost. What was the total amount of cost? Was it $12.53?
That is the fines and the cost. Are you asking for just the cost?
Okay. What's the additional cost first?
The new costs are $264.06.
Okay. $264.06 in additional cost. Extend the C&D for 5 years from today. Total cost and fines are how much? Was it 12? You gave me a 12.53.
12.53.46.
46. Okay, that's cost and
Cost, it's fines, new cost, and the unpaid cost from the
how much
previous
is,
order.
without the cost? How much are the fines?
600.
Just 600. What about the $50 from previous?
They came into compliance at
so
that
it was
moment.
never assessed.
Those were never assessed,
Okay,
correct.
so $600 in fines, in addition to the cost. Okay. Do I need to give them another hearing date?
No, if she finds it again, we have to renotice them.
Okay.
I mean, you
So-
could.
No.
Could set a potential hearing. If she doesn't find it, then we won't take it forward. If she finds it, then we'll.
Well, is the $100 a day, Steve, is it running? So if there's,
No, it's a
No,
fixed fine right
Yes,
now.
it's fixed.
okay, well, what I'm gonna do is, in addition to what's fixed fine, I'm gonna give them until February, well, I'm not gonna give them, I'm just gonna have another hearing on February 21st, 2019, for any additional violations at $100 per day. What, okay, so before we go to the next case, let me just ask a question. Do we have, and this is village council's really a question for her, about towing these vehicles when they're repeat offenders? I mean, because we just keep finding them and we don't do anything.
Right, right.
And
We
it's home-
can't-
And it's homestead and you can't
Right, we
assess
can't
anything?
we can't tow off private property. The only time, the village code, the only time we're allowed to permit to tow a car if it's abandoned on, and it has to be on the right of way. That we can tow a car.
So we can't tow it from a driveway.
I think that's an overreach of our police powers, is the.
What about
try to-
putting a sign on the windshield with a sticky that says you're in violation?
No, the code has to go above and beyond to contact people before we fine them. So,
Well, you've gone over and above, okay, and we're fining them, but we're not having any,
unfortunately, you know, well, we enjoy a very high compliance rate, but we do have that 2% that don't comply. So this is one of that 2%.
yeah, but on certain things, we could go into the property when it's a safety issue, right? And take care of pools.
Correct.
We could mow lawns,
Yes.
but we can't remove vehicles. I mean, I'm not saying the law, but we should be able to do, there's gotta be something when they're a repeat offender. We put a boot on them.
Well, I mean, there are
can we-
other civil remedies that we can seek through 162. We don't, in my experience, we don't have a whole lot of success with them. You know, obviously, we can't foreclose, but we can
Right.
go for a money judgment, and in my experience, we haven't had much luck doing that.
Yeah, and that takes time, too. I'm just thinking about how to get the vehicle out of there. I mean, we could post notice on the garage door. Can we post notice on the vehicle that they're in violation with something sticky? Like, a lot of associations will do that. I know they're not municipalities, where they said, your vehicle is not in compliance with code section, boom, 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 please remove. And it's hard to get those stickers off.
I mean,
You're not damaging them, but you can get them off, but they're hard.
Yeah, the ordinance doesn't speak to us being like, I mean, we can go out there and we can
Well,
put
it
something
may
on the
be
car to
something,
remind them,
again-
of what's going on. I mean, ultimately, really the ultimate enforcement for us is eventually they're going to try to sell the house, they're gonna try to refinance, they're gonna try to do something, and that's when the lien's gonna come to the surface.
Could be 30 years.
Yeah, unfortunately. I said, you know, we enjoy a very, very high compliance rate,
I
but there are other
understand
ones, and it's frustrating for us as well.
Is this a duplex, a quad area?
That's a single family.
Single family? Well, if I was a neighbor, I'd be upset that there's nothing the village can do.
Well, I'll speak to Lena about it, and maybe we'll add that on to the things to speak to the village attorney about.
Okay.
To see if there's any other
Any other
avenues.
remedy?
Yeah.
Or any other action you could take or something to get their attention? Or maybe block their driveway so they can't get out. So, okay, next case. Thank you.
Okay, so next case will be item number 6, NOH 18-4502.
Lena Bott, Code Officer for the Village of Wellington. Case number NOH 18-4502. Respondent name, Eva Salam. Property address, 1394 Sailboat Circle, Wellington, Florida, 33414. This case was established based on a complaint. The NOVNOH was served by certified mail, return receipt received. The correction date was January 3, 2019. An inspection on January 4, 2019 found the following items remained beyond the time given in the notice in violation of Wellington Code Section 36-22B1, roof and walls stained and discolored. Wellington's Code Section 36-32B1, garbage can not completely screened from view. Land Development Regulations Section 6.5.19.E.10, mechanical equipment not screened from view, but found Wellington Code Section 36-22B1, driveway and sidewalk stained and discolored, had been corrected. Photos were taken that represent the condition of the property at the time of the various inspections. Staff conducted a PACER search, which found the respondent does not have pending bankruptcy action, and there's not a list pendants filed against this property. 2 door hangers were left, one on August 24, 2018, and a second one on October 30, 2018, to which the owner did not respond. The Code Compliance Division recommends the respondent be found in violation of Wellington Code Sections 36-22B1, 36-23B1, and Land Development Regulation Section 6.5.19.E.10. It is recommended that the respondent be given until February 17, 2019 to correct the violations or be charged a fine not to exceed $25 per day per violation for each day the violation continues to exist. It is also recommended that costs incurred by the Code Compliance Division in the amount of $281.53 be assessed and ordered to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and/or the violations are not corrected, it is recommended that a fine certification hearing be held before the Special Magistrate on February 21, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida, 33414. It is also recommended that no additional notification of the intent to impose a fine be given.
Okay. Case number NOH 18-4502, I'm going to dismiss 36-22B2. I make the following findings of fact. I find that the respondent was served with notice. Respondent was not present. Code Compliance Officer was present based on the testimony, the photographs, and the other documents introduced into evidence. I find that the respondent is in violation of 36-23B1, garbage can not screened from view. 36, let me see what the other one is. No, 36-22B, which one is it we dismissed to? B1. Which one did we dismiss?
I'm sorry, 36-22B2 is what we dismissed.
Okay, is that the correct one, the sidewalks, or is it the roof?
Driveway and sidewalk were corrected,
Yeah,
yes.
okay, so 36-22B1, roof is stained, walls are stained, mailbox is stained, balcony stained and discolored. And They're in violation of LDR section 6.5.19.E.10, mechanical equipment not screened from view, meaning their air conditioner unit. And give them until February 17th, 2019 to come into compliance. Thereafter, $25 per day per violation, cost of $281.53, 5-year C&D. And in the event Code Compliance Division is not contacted as required and/or the violations are not corrected, a fine certification hearing shall be held before the Special Magistrate on February 21, 2019 at 9 o'clock a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to impose a fine shall be given. Okay, next case.
Next case will be item number 7, NOH 18-5143.
Lena Bott, Code Officer for the Village of Wellington. Case number NOH 18-5143. Respondent name, Progress Residential 2015-1, borrower LLC. Property address 12740 Westport Circle, Wellington, Florida 33414. This case was established based on a complaint. The NOV-NOH was served by certified mail, return receipt received. Correction date was January 3, 2019. An inspection on January 4, 2019 found the following items remained beyond the time given in the notice in violation of Wellington Code Section 36-22B1, walls and mailbox stained and discolored, 36-22B2, driveway and sidewalk stained and discolored, and 36-23B1, garbage can not completely screened from view. Photos were taken that represent the condition of the property at the time of the various inspections. Staff conducted a PACER search, which found the respondent does not have pending bankruptcy action and there's not a list pendants filed against this property. There was 2 separate emails exchanged, one on October 12, 2018, which was a detailed email with the remaining violations from the Code Compliance Officer in response to the email stating that all violations had been corrected. 2 additional weeks were granted at that time. And on October 29, 2018, a follow-up inspection was done following this 2-week extension, and an email with the list of remaining violations was sent to the owner, to which there was no response. The Code Compliance Division recommends the respondent be found in violation of Wellington Code Sections 36-22B1, 36-22B2, and 36-23B1. It is recommended that the respondent be given until February 17, 2019 to correct the violations or be charged a fine not to exceed $50 per day per violation for each day the violations continue to exist. It is also recommended that costs incurred by the Code Compliance Division in the amount of $264.21 be assessed and ordered to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and/or the violations are not corrected, it is recommended that a fine certification hearing be held before the Special Magistrate on February 21, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida 33414. It is also recommended that no additional notification of the intent to impose a fine be given.
Okay, what was the amount of the cost you incurred in this?
$264.21.
Okay. Can they pressure clean that rust off? Will that come off? Anybody?
Can they pressure clean it off?
Oh, how do you clean the rust? Will they be able to do that?
Aside of pressure cleaning, there's other chemical treatments that are
Okay,
possible.
there's a way to get rid of the rust.
Yeah, we've seen done.
Okay. Case number 18-5143. I'm going to make the following findings of fact. A fine notice was served on respondent. Respondent was not present. Code Compliance Officer was present based on the testimony of the Code Compliance Officer together with the photographs and notices and other documents introduced into evidence. I find that the respondent is in violation of Code Section 3622B2, sidewalks and driveway stained and discolored. Section 3623B1, garbage can not not screened from view, and code section 3622B1, wall stained and discolored. I'm going to give them until February 17th to come in compliance, $25 per day per violation, cost of $264.21, 5 years C&D, and in the event code compliance division is not contacted as required and/or the violations are not corrected, a fine certification hearing shall be held before the special magistrate on February 21, 2019 at 9:00 a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to pose a fine shall be given.
Thank you.
Okay, thank you. Okay, next case.
Next case will be item number 9, NOH 18-5455. Todd Gregory is the code officer.
Todd Gregory, Code Officer for the Village of Wellington. Case number 18-5455. Respondent's name is Elizabeth A. Walkinshaw. Property address 1136 Larch Way, Wellington, Florida. This case was established based on a complaint. NOV was served and certified mail return receipt received. Correction date was January 7th, 2019. Inspection on January, I got the wrong date on here. January 9th, follow-up inspect, the following items remain beyond the time given in the notice of violation. Wellington Code Section 7.14.8.I.1. No address numbers on the house. A photo was taken at the time to represent the condition of the property. A follow-up inspection on January 15th found the violation still exists. Staff conducted a PACER search which found the respondent does not have a pending bankruptcy action or lis pendens. On January 8th, 2019, while driving past the property, I seen a guy out in the front yard, and I stopped and talked to him and just told him I was there as a courtesy to tell him that if they didn't correct the violation and they keep leaving their, another case is they keep leaving their garbage cans out. I told him they were going to start getting fined, and his response was, whatever, dude. And turned around and walked away. The Code Compliance Division recommends the respondent be found in violation of Wellington Code Section 7.14.8.I.1. It is recommended that the respondent be given until February 21st, 2019 to correct the violation or be charged a fine not to exceed $25 per day for each day the violation continues to exist. It is also recommended that the cost incurred by the Code Compliance Division in the amount of $212.26 be assessed in order to be paid within 30 days of the date of this meeting. A cease and desist order for the period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and or the violations are not corrected, it is recommended that a fine certification hearing be held before the special magistrate on March 21st, 2019 at 9 a.m. at Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida. It is also recommended that no additional notification of intent to pose a fine be given.
Okay. Is there at least a number on the mailbox on the other side?
There is one on the mailbox, on the other side of it.
Okay.
It's really hard to see though, it's really faded.
Oh. Case number 18-5455. Make the following findings of fact. A fine notice was served on respondent. Respondent was not present. Code compliance officer was present. Based on the testimony of the code compliance officer together with the photographs, notices, and other documents and evidence, I find respondent in violation of Wellington Land Regulation 7.14.8.L.1. No address on the building. I'm going to give them until February 1st, 2019 to come into compliance. Thereafter, I'm going to assess a fine of, should not be hard to do. Let's say $35 a day. No man's land, okay? Cost of $212.26, 5 years C&D, And in the event Code Compliance Division is not contacted as required and/or the violations are not corrected, a fine certification hearing shall be held before the special magistrate on February 21, 2019, at 9 o'clock a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to pose a fine shall be given.
Thank you.
Okay, thank you.
Next case is item number 10, 18-5661. John Jarvis is the code officer.
John Jarvis, Code Officer with Wellington, case number NOH 18-5661. Respondent's name is Sedelia Christina Torres. Property address is 1314 the 12th Fairway, Wellington, Florida. This case was based on a neighborhood improvement inspection. The NOH was served by posted notice on December 18, 2018 at the property and at the Wellington Municipal Complex. Correction date was January 8, 2019. An inspection on January 14th found the following items remain beyond the time given in the notice in violation of Wellington Code Section 3622B1. The roof and front wall are stained and discolored, and 3622B2, the parking surface and sidewalk are stained and discolored. Photos were taken that represent the condition of the property at the time of the various inspections. Follow-up inspection on January 16th found the violations still exist. Staff conducted a PACER search which found the respondent does not have pending bankruptcy action. Research found there is not a list pendants filed against this property. I've had no contact with the owner. A door hanger was left on November 7th. I did speak with the tenants on the evening of January 7th, who informed me they had just moved in, and the real estate agent did inform them some sort of pressure cleaning work would be done shortly. I left a phone message for the real estate agent the next morning. However, I've had no response. The Code Compliance Division recommends the respondent be found in violation of Wellington Code Sections 3622B1 and 3622B2. It is recommended that the respondent be given until February 21st, 2019 to correct the violations or be charged a fine not to exceed $25 per day per violation for each day the violations continue to exist. It is also recommended that costs incurred by the Code Compliance Division in the amount of $249.08 be assessed in order to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and or the violations are not corrected, it is recommended that a fine certification hearing be held before the Special Magistrate on March 21st, 2019 at 9 a.m. at the Wellington Municipal Complex, 12,300 Forest Hill Boulevard, Wellington, Florida. It is also recommended that no additional notification of the intent to impose a fine be given.
Okay, thank you. Case number NOH 18-5661. I'm going to make the following findings of fact. Find respondent was served with notice. Respondent is not present. Code Compliance Officer was present. Based on the testimony, Code Compliance Officer, together with the photographs, notices, and other documents introduced into evidence, I find respondent in violation of Section 3622B1, roof and front wall stained and discolored. Section 3622B2, driveway and sidewalk stained and discolored. Give them until February 21 to come into compliance. Thereafter, a fine of $25 per day per violation, cost of $249.08, 5 years C&D. And in the event Code Compliance Division is not contacted as required and or the violations are not corrected, a fine certification hearing shall be held before the Special Magistrate on March 21, 2019 at 9 o'clock a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to pose a fine shall be given.
Thank you.
Thank you.
Next case is item number 11, NOH 19-98.
Okay. John Jarvis, Code Officer with Wellington, case number NOH 19-98. Respondent's name is Rashini Gopi. Property address is 975 Lantern Tree Lane, Wellington, Florida. This case was established based on a complaint. The NOH was served by certified mail, return receipt received. Correction date was January 6, 2019. An inspection on January 14 found the following items remain beyond the time given in the notice in violation of Wellington Code Section 3622B1. The wood trim is deteriorated, the rear door is stained and discolored, and the screen enclosure is torn. And 3622B2, the sidewalk and driveways for both units are stained and discolored. Photos were taken that represent the condition of the property at the time of the various inspections. Follow-up inspection on January 16th found the violations still exist. Staff conducted a PACER search which found the respondent does not have pending bankruptcy action. Research found there is a lis pendens filed against this property, with the last item on the docket being the plaintiff's affidavit of default and motion to enforce stipulation and settlement agreement dated September 26th, 2018. There's been no contact with the owner. The Code Compliance Division recommends the respondent be found in violation of Wellington Code Section 3622B1 and 3622B2. It is recommended that the respondent be given until February 21st, 2019 to correct the violations or be charged a fine not to exceed $25 per day per violation for each day the violations continue to exist. It is also recommended that costs incurred by the Code Compliance Division in the amount of $229.58 be assessed and ordered to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and or the violations are not corrected, it is recommended that a fine certification hearing be held before the Special Magistrate on March 21st, 2019 at 9 a.m. at the Wellington Municipal Complex, 12,300 Forest Hill Boulevard, Wellington, Florida. It is also recommended that no additional notification of the intent to impose a fine be given.
The weeds in this property look worse than the previous hearing we had. So, case number NOH 1998. Make the following findings of fact. A fine notice was served on the respondent. Respondent was not present. Code compliance officer was present. Based on the testimony of the code compliance officer, together with the photographs, notices, and other documents presented into evidence, a fine respondent in violation of Code Section 3622B1. Wood trim is at the rear is deteriorating, rear door stained, and screen enclosure is torn. And Code Section 3622B2, driveway and sidewalk stained and discolored. I'm going to give them until February 21 to come into compliance. Thereafter, a fine of $25 per day per violation, cost of $229.58, 5 years C&D, and in the event the Code Compliance Division is not contacted as required, and/or the violation is not corrected, a fine certification hearing shall be held before the Special Magistrate on March 21, 2019, at 9:00 a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to pose a fine shall be given.
Thank you.
Okay, thank you.
Okay, next case is item number 13, NOH 19-646, Code Officer Deborah Mitchell.
Good morning. Deborah Mitchell, Code Compliance Officer with the Village of Wellington. Case number 19-646. Respondent's name is Erica Lynn Cook Bender. Property address is 1441 Wincliffe Drive, Wellington, Florida. This case was established based on a neighborhood improvement inspection. The NOV/NOH was served by certified mail, return receipt received. Correction date was December 12, 2018. An inspection on January 5, 2019 found the following items remain beyond the time given in the notice in violation of Wellington Code Section 62-9C, commercial vehicles on property beyond the time allowed. Photos were taken that represent the condition of the property at the time of the various inspections. A follow-up inspection on January 6th, 9th, and 13th, 2019 found the violations still exist. The staff conducted a PACER search which found the respondent does not have a pending bankruptcy action. Research found there is not a lis pendens filed against this property. I spoke with Ryan Bender on January 13th and we discussed covering the signage on his truck and removing the commercial trailer. I had a previous case on this property for commercial vehicles that was dismissed from the hearing on May 7th, 2018. At that time, he had a blank magnet made for his truck, and he was not parking any trailers on the site at that time. The Code Compliance Division recommends the respondent be found in violation of Wellington Code Section 62-9C. It is recommended the respondent be given until January 27, 2019 to correct the violation. or be charged a fine not to exceed $50 per vehicle per day for each day the violation exists. It is also recommended that costs incurred by the Code Compliance Division in the amount of $322.32 be assessed in order to be paid within 30 days of the date of this meeting. Cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and/or the violations are not corrected, it is recommended that a fine certification hearing be held before the special magistrate on February 21st, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida. It is also recommended that no additional notification of the intent to impose a fine be given.
Okay, thank you. Case number NOH 19646. Make the following findings of fact. Find the respondent was served with notice, was not present. Code compliance officer was present based on the testimony of the code compliance officer, together with the photographs, notices, and other documents introduced into evidence. I find the respondent in violation of Code Section 62-9C, commercial vehicle and trailer parked on the property. I'm going to give them until, I think I gave everybody February 1, 2019 to come into compliance. Thereafter, a fine of $50 per day per vehicle. Cost of, what was it, $322.32?
Correct.
5 years C&D, and in the event Code Compliance Division is not contacted as required and/or the violations are not corrected, a fine certification hearing shall be held before the special magistrate on February 21, 2019 at 9 o'clock a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to impose a fine shall be given. What's that? Next case.
Missing a code officer. We're going to move to item number 2 under fine certification, NOH 18-2685. Todd Gregory is the code officer. Shane, can you find out what Lena is? Thanks.
Todd Gregory, code officer for the Village of Wellington. Case number NOH 18-2685. Respondent's name, that's the one we're on, right? Eric Ralou. Property address 1215 Carriage Lane, Wellington, Florida. 12150 Carriage Lane. The hearing date for this case has had 2 STIP agreements, or it's had a STIP agreement with 2 extensions. The respondent was ordered to correct the violations of Code Section 18-32-105.1 on or before January 6, 2019, or pay a fine not to exceed $25 per day. The order also scheduled a fine certification hearing for January 17, 2019 if the Code Compliance Division was not contacted as required and or the violations were corrected. Inspection on January 7, 2019 found the shed installed without first applying for a building permit in violation of Wellington Code Section 1832-105.1. Follow-up inspection on January 15, 2019 found the violation still exists. Pacer search found that the respondent does not have a pending bankruptcy action or lis pendens against the property. There's been several emails sent and received between this owner and the code department and the building department. And I talked to the building department yesterday, and they said he said he's going to give them what they need. He just hasn't done it. And like I said, he's had 2 extensions on a STIP agreement. The Code Compliance Division recommends the respondent be found in violation of the order Wellington Code Section 1832-105.1, and that the respondent be assessed a fine in the amount of $25 per day commencing on January 7, 2019, and cost in the amount of $382.76, which includes costs assessed in the order, both continuing to occur until the violations are corrected.
Okay. Case number NOH 18-2685. I find respondent in violation of the order and certify fine the amount of $25 per day from January 7th, 2019, and cost of $382.76.
Thank you.
Next case.
Okay, next case, we go back to item number 1. On page 5 on the fine certification is NOH 18-145. Lena Bott is the code officer.
Lena Bott, Code Compliance Officer for the Village of Wellington. Case number NOH 18-145. Respondent names Sean L. Needbalski and Elizabeth Welsh Needbalski. Property address 13574 Northumberland Circle, Wellington, Florida 33414. The date of the hearing was December 13, 2018. The respondent was ordered to correct a violation of Code Section 6.6.4.f.2 on or before January 7, 2019, or pay a fine not to exceed $100 per day. The order also scheduled a fine certification hearing on January 17, 2019, if the Code Compliance Division was not contacted as required and/or the violation was not corrected. An inspection on January 11, 2019 found an unapproved fence type in violation of Wellington Land Development Regulation 6.6.4.f.2. A PACER search found the respondent does not have pending bankruptcy action and there's not a list pendants filed against this property. On January 8, 2019, the respondent made a visit to the office to discuss the order and the violation. It was explained that the resolution was the correction of the violation, which the respondent explained had not yet occurred. Instructions were given on how to request an order of time extension, since it appeared that's what he needed, which was not actioned as of January 11, 2019. The Code Compliance Division recommends the respondent be found in violation of the order and Wellington Land Development Regulations Section 6.6.4.f.2, that the respondent be assessed a fine in the amount of $100 per day commencing on January 8, 2019, and the costs in the amount of $472.52, which includes costs assessed in the order, both continuing to accrue until the violation is corrected.
Okay. Case number NOH 18-145. I find respondent in violation of the order and certify a fine in the amount of $100 per day from January 8, 2019, and cost of $472.52. Okay, next case.
Next case will be item number 3, NOH 18-3515.
Todd Gregory, Code Compliance Officer for the Village of Wellington. Case number NOH 18-3515. Respondent's name, Fabilia Montero and Victor A. Becker. Property address 1053 Summerwood Circle, Wellington, Florida. Hearing date was December 13, 2018. The respondent was ordered to correct the violation of Code Section 62-9C on or before December 27th, 2018, or pay a fine not to exceed $25 per day. The order also scheduled a fine certification hearing on January 17, 2019, if the Code Compliance Division was not contacted as required and or the violation was not corrected. An inspection on January 11th found a red pickup truck with black cargo trailer in tow parked or stored on the property in a residential neighborhood in violation of Wellington Code Section 62-9C. Photos were taken at the time that represent the condition or represent the violation at the time of the inspection. PACER search found the respondent does have a pending bankruptcy action. Research found that there is a lis pendens against the property. The last action on the docket was a stay in closing of the file, and the plaintiff was ordered to monitor the status of the bankruptcy and the clerk to close the file. On November 29, 2018, I left a door hanger asking someone to call me about this case and never got a response. Code Compliance Division recommends the respondent be found in violation of the order of Wellington Code Section 62-9C and that the respondent be assessed a fine in the amount of $25 per day, or $25 for each time the violation is found. Commencing on December 28, 2019, and a cost in the amount of $591.16, which includes costs assessed in the order, both continuing to occur until a violation is corrected.
Do they continue to park?
All the time.
I see Mr. Posner proposed a fine of $25 per day. I think case number NOH 183515, I'm going to find in violation, I'm going to find the respondent in violation of the order and certify a fine in the amount of, I'm going to increase that to $50 per day, they can appeal that, and cost of $591.16. And that's going to run from December 28th, 2018. And I guess every day, each day that they're in violation, that's a per day thing, right? It just can't, it doesn't run, it's just only when they park there,
It's when we see it there.
whenever you see it.
Right.
Right now, you're asking
But
for
I'm-
what days then? You're asking.
Yeah, is there any specific date? Because I can't just do it from December 28th if they haven't been in violation since then.
Well, it was there on January 9th, or I'm sorry, it wasn't there. It was there on January 11th.
Okay.
So I guess it would be from
When-
every time from now that,
Was there anything after, other than January 11th, anything after December 28th or anything after December 27th, I guess? You only saw it one time since then?
yes, sir.
Okay. So it's going to be $50 per day whenever observed after December 28th, and so far it's January 11th, 2019.
Right.
Okay, so it's $50 right now. The cost is $591.16. Okay. So that'll continue to accrue, right? We wouldn't have to
No,
come
he
back.
has to,
So if
you'd
they,
have to re-notify him once he sees it again. We're required to.
It's
not
be a repeat
continuing?
violation.
No,
so it's
It'll be
just a
repeat
$50,
violation.
for the one day.
okay? All right.
But I'm sure, I'm going to go there tonight, and I'm sure it'll be there tonight, and I'll go
You got to
and have somebody.
renotice it again.
All right, thank you.
Okay.
Next case is item number 5, NOH 18-4468. Feroz Khalil is the code officer.
Morning.
Good morning,
Rose Khalil, Code Compliance Officer for the Village of Wellington. Case number NOH 18-4468. Respondent's name, Catherine Garofalo, Judy Garofalo Torres. Property address, 15355 Earhart Place, Wellington, Florida. Hearing date, November 15, 2018. The respondent was ordered to correct the violation of Code Section 1832-105.4 on or before January 10, 2019, or pay a fine not to exceed $50 per day. The order also scheduled a fine certification hearing on January 17, 2019, if the Code Compliance Division was not contacted as required and or the violation was not corrected. Inspection on January 11, 2019 found expired permit 154263 for a kitchen and bathroom remodel. No contractor of record and no inspections performed, in violation of Wellington Code Section 1832-105.4. A follow-up inspection on January 16, 2019 found the violation still exists. A Pacer search found the respondent does not have pending bankruptcy action or a list pending file against this property. Contact with the owner, none. The Code Compliance Division recommends the respondent be found in violation of the order, Wellington Code Section 1832-105.4, and that the respondent be assessed a fine in the amount of $50 per day, commencing on January 11, 2019, and cost in the amount of $368.62, which includes costs assessed in the order, both continuing to accrue until the violation is corrected.
Okay, case number NOH 18-4468, I find respondent in violation of the order and certify a fine in the amount of $50 per day from January 11th, 2019, cost of $368.62.
Thank you very much.
Next item is case number 6, NOH 18-4774.
Good morning.
Morning.
Natalie Pardo, Code Officer for the Village of Wellington. Case number NOH 18-4474. Respondent name 2018 3IH Barrow LP Invitation Homes. Property address is 3647 Chesapeake Court. Hearing date was December 13th, 2018. The respondent was ordered to correct the violation of Code Section 36-23B1, garbage cans not completely screened from view, on or before December 27th, 2018, or pay a fine not to exceed $25 per day. The order also scheduled a fine certification hearing on January 17th, 2019, if the Code Compliance Division was not contacted as required and or the violations were not corrected. An inspection on December 28th, 2018 found garbage cans not completely screened from view in violation of Wellington Code Section 36-23B1, which is in violation of the order. Photos were taken that represent the condition of the property at the time of the various inspections. A follow-up inspection on January 11th, 2019, found the violation still exists. A PACER search found the respondent does not have pending bankruptcy action or a lis pendens filed against this property. There's been quite a few correspondence with the property manager, Mary, with Invitation Homes, and she's trying to get the tenants to work with her. The Code Compliance Division recommends the respondent be found in violation of the order, Wellington Code Section 36-23B1, that the respondent be assessed a fine in the amount of $25 per day, commencing on December 28, 2018, and costs in the amount of $392.60, which includes costs assessed in the order, both continuing to accrue until the violations are corrected.
Okay. Case number NOH 18-4474. I find respondent in violation of the order and certify fine in the amount of $25 per day from December 28th, 2018. Again, this is only when you spot these, right?
Right.
Yes.
So this is 2 times? November 11th, you said, and what was the other date? The 28th?
So the first was the 28th, and then the next time I went out was the 11th.
It's only 2 times,
2
okay.
times.
So the fine is for those 2 days, the 28th and January 11th, 2019, cost of $392.60. Okay, thank you.
Next case will be item number 7, NOH 18-5098. Lena Bott is the code officer.
Lena Bott, Code Compliance Officer for the Village of Wellington. Case number NOH 18-5098. Respondent name Michael S. Allard and Nicole M. Allard. Property address 11688 Turnstone Drive, Wellington, Florida 33414. The hearing date was November 15, 2019, which the stipulation agreement went on consent. The respondent was ordered to correct the violations of Code Sections 36-22B1, 36-22B2, 36-23B1, 36-23B3, and Wellington Land Development Regulations Section 7.3.12.b on or before January 7, 2019, or pay a fine not to exceed $25 per day per violation. This order also scheduled a fine certification hearing on January 17, 2019, if the Code Compliance Division was not contacted as required and or the violations were not corrected. An inspection on January 10, 2019 found only the garbage can not completely screened from view in violation of Wellington Code Section 36-23B1. Photos were taken that represent the condition of the property at the time of the various inspections. A PACER search found the respondent does not have pending bankruptcy action, and there is not a list pendants filed against this property. There was some communication prior to the stipulation agreement being signed, which was November 2nd, 2018. It was a telephone conversation with Mr. Allard to discuss the violations, and that was when we initially offered him a stipulation agreement. And then on November 13, 2018, after the stipulation agreement was signed, Mrs. Allard called to go over the remaining violations. The Code Compliance Division recommends the respondent be found in violation of the order, Wellington Code Section 36-23B1, that the respondent be assessed a fine in the amount of $25 per day commencing on January 8, 2019, and costs in the amount of $376.62, which includes costs assessed in the order, both continuing to accrue until the violation is corrected.
Okay, so let me see if I understand. Which code section are they still in violation of?
36-23B1. Garbage can, not completely screened from view.
Everything else they're in compliance with?
Yes.
Okay, and what days have you observed since January 8th, the garbage can?
Well, it's not screened,
Oh, just,
so it's not a per,
it's always there?
yes.
Every day, and that's screened?
Yeah, it's not at the curbside or anything like that. It's
It's not in front of the
not
garage?
permanently screened.
All right. Okay, case number NOH 18-5098. I find respondent in violation of the order as to section 3623B1 and certify a fine in the amount of $25 per day, cost of $376.62.
Thank you.
Excuse me, from January 8th, right. Okay,
Thank you.
thank you. Sorry about that.
Next case is item number 8, NOH 18-5346. Natalie Pardo is the code officer.
Natalie Pardo, Code Officer for the Village of Wellington. Case number 18-5346. Respondent name IH5, Property Florida LP Invitation Homes. The property address is 10777 Pelican Drive. Hearing date was December 13, 2018. The respondent was ordered to correct the violation of Code Section 36-22B2, driveway in a state of deterioration, on or before January 10, 2019, or pay a fine not to exceed $50 per day. The order also scheduled a fine certification hearing on January 17, 2019, if the Code Compliance Division was not contacted as required and or the violations were not corrected. An inspection on January 11, 2019, found driveway in a state of deterioration in violation of Wellington Code Section 36-22B2, which is in violation of the order. Photos were taken that represent the condition of the property at the time of the various inspections. A PACER search found the respondent does not have a pending bankruptcy action or a lis pendens filed against this property. Again, email and phone correspondence with Mary from Invitation Homes many times about this property. The Code Compliance Division recommends the respondent be found in violation of the order, Wellington Code Section 36-22B2, that the respondent be assessed a fine in the amount of $50 per day commencing on January 11th, 2019, and costs in the amount of $400.59, which includes costs assessed in the order, both continuing to accrue until the violations are corrected.
All right, thank you. Case number NOH 18-5346. I find respondent in violation of the order and certify fine in the amount of $25 a day from January 11th, 2019, cost of $4.59.
Thank you.
Next case?
Next case will be item number 9, NOH 19-434. Deborah Mitchell is the code officer.
Mm-hmm, yes. You can, we don't need any photos.
Okay. Deborah Mitchell, Code Compliance Officer with the Village of Wellington. Case number NOH 19-434. Respondent's name is Hillary A. Gibbs. Property address is 11992 Sue Ellen Circle, Wellington, Florida. Hearing date was December 13, 2018. The respondent was ordered to correct the violations of Wellington Code Section 3623B1, 3623B3, and 3623C2 on or before December 27, 2018, or pay a fine not to exceed $25 per day per violation. The order also scheduled a fine certification hearing on January 17, 2019, if the Code Compliance Division was not contacted as required and/or the violations were not corrected. An inspection on January 3rd, 2019 found the following items remain beyond the time given in the notice in violation of Wellington Code Section 3623B1, trash container not screened from view when stored. Code Section 3623B3, accumulation of litter and trash on the property. And Code Section 3623C2, household items visible from the street, which is in violation of the order. Photos were taken that represent the condition of the property at the time of the various inspections. A follow-up inspection on January 6th, 9th, 14th, and 16th, 2019 found the violations still exist. Pacer search found the respondent does not have pending bankruptcy action. Research found there is not a list pendants filed against this property. I spoke with the homeowner on site on January 3rd and explained the violations. Code Compliance Division recommends the respondent be found in violation of the order. Wellington Code Section 3623B1, 3623B3, and 3623C2. And the respondent be assessed a fine in the amount of $25 per occurrence on January 3rd, 6th, 9th, 14th, and 16th, 2019. That's 5 days at $75 for a total fine of $375, and costs incurred in the amount of $484.33, which includes costs assessed in the order, for a total amount of $859.33.
All right, case number NOH 19434. I find respondent in violation of the order and certify a fine in the amount of $25 per day per violation per occurrence. And what was it, 5 days?
It's 5 days at $75.
Okay, 5 days, cost of $484.33 for, I'll let you add up the total. The total was $859.32, but I don't know how you
I thought it was 33.
broken down.
Maybe I was wrong. 33, yeah.
Okay, does it work?
It's $375 worth of fines.
Fines.
And then the
Okay.
costs.
Okay?
Is that right? All right, thank
Okay,
you.
we got the math. Very good, thank you. Next case.
Item number 10 is NOH 19-464. Natalie Pardo is the code officer.
Natalie Pardo, Code Officer for the Village of Wellington Code Enforcement. Case number 19-464. Respondent named Catherine Grace Kohlhaas. Property address is 4358 Wellington Shores Drive. The hearing date was December 13th, 2018. The respondent was ordered to correct the violation of Code Section 36-23B1, garbage cans not completely screened from view, on or before December 27, 2018, or pay a fine not to exceed $25 per day. The order also scheduled a fine certification hearing on January 17, 2019, if the Code Compliance Division was not contacted as required and or the violations were not corrected. An inspection on January 4th, 2019 found the garbage cans were not completely screened from view in violation of Wellington Code Section 36-23B1. Photos were taken that represent the condition of the property at the time of the various inspections. A follow-up inspection on January 10, 2019, found the violation still exists. A Pacer search found the respondent does not have pending bankruptcy action or Liz pendants filed against this property. Contact with the owner, there's been no contact with them. The Code Compliance Division recommends the respondent be found in violation of the order, Wellington Code Section 36-23B1, that the respondent be assessed a fine in the amount of $25 per day, commencing on December 28, 2018, and costs in the amount of $417.22, which includes costs assessed in the order, both continuing to accrue until the violations are corrected.
Okay, how many days have they been in violation since December 28th?
I'll tell you right now.
Is that where it's permanently stored?
What?
Is that where it's permanently stored?
Yes.
It's always there? Well,
Yes. She has a sign on there that says she's not going to move it.
but how many days have you seen it out there?
Okay, well, since,
There is a sign on one of the cans.
yes,
At least she's letting
it's,
us know.
I'm sorry, give me one moment. Okay, so one,
This one has to
Two.
be per occurrence,
yes, 2 times.
2 times. And the dates, what dates are those?
The first one was the 4th, the 8th, and the 10th of January.
The 4th, 8th, and what? That's 3
4th,
times.
8th, and 10th. So 3, I'm sorry.
3 times, okay,
3 times.
$75. Okay, case number NOH 19-464. I find respondent in violation of the order and certify a fine in the amount of $25 per day per occurrence. 3 days, January 4th, 8th, and 10th, and cost of $417.22.
Thank you.
Okay, next case.
Next case is item number 11, NOH 19-472. Todd Gregory is the code officer.
Todd Gregory, Code Officer for the Village of Wellington. Case number NOH 19-472. Respondent's name is Muhammad Ali. Property address 11717 Pintel Drive, Wellington, Florida. Hearing date was December 13, 2018. The respondent was ordered to correct the violation of Code Section 62-9C on or before December 27, 2018, or pay a fine not to exceed $25 per occurrence. The order also scheduled a fine certification hearing on January 17, 2019. The Code Compliance Division was not contacted as required, and or the violations were not corrected. Inspection on January 4th found the commercial vehicle parked in the residential neighborhood in violation of Wellington Code Section 62-9C. A photo was taken at the time of the inspection. Pacer search found the respondent does not have pending bankruptcy or lives pendants. On January 4th, when I was there taking the picture, I'd seen the lady out in the front yard that had the same shirt on as the name of the tow truck. And I told her I was there as a courtesy and that she was going to start getting fined every time I seen it there. And she basically told me that she hasn't had no communications telling her that it was a problem. And she currently has 3 open liens from the past 15 years because of this same tow truck. So she knows, I told her she's had plenty of notification. The Code Compliance Division recommends the respondent be found in violation of Order Wellington Code Section 62-9C, and that the respondent be assessed a fine in the amount of $25 per occurrence commencing on December 28, 2018, and costs in the amount of $465.17, which includes costs assessed in the order, both continuing to occur until the violations are corrected.
Okay, case number NOH 19-472. I find respondent in violation of the order, certify a fine in the amount of $50 per day per occurrence as of December 28, 2018. I think there was one day, January 4th, 2019, that code enforcement officer testified to, and cost of $465.17.
Just one day.
One day, right? You only
Yep,
seen it one
that's
day
it.
since then? Okay.
Thank you.
Okay, what we're going to do is take a 10-minute recess, and we'll deal with the last case on the agenda. Morning. Dandy, how you doing? Good. Enforcement hearing. Next case? I think
Next
it's our
case will be
last.
item number 12 under new business on page 4. The NOH 19-129. Deborah Mitchell is the code officer.
Deborah Mitchell?
Alexander Dom on behalf of Palm Beach Polo, Inc. Before we begin, I'm going to put in my objection to this particular hearing. We have provided the magistrate with some exhibits. Hopefully you have them in front of you. Going through them briefly. Florida Statute 162.05 subsection 1 provides that the local governing board may appoint one or more code enforcement boards and legal counsel for the enforcement boards. In looking at 162.03, which is your next document, it provides that a special magistrate shall have the same status as an enforcement board under this chapter. References in this chapter to an enforcement board, except in 162.05, shall include a special magistrate. The context exists. And finally, I would like to call your attention to Wellington Code Section 2-203 regarding special magistrates. And it says that one or more persons may be appointed as special magistrate by Wellington's council. It also says that the compensation for special magistrate services may be authorized as specified in the appointing resolution. My point to all of this is, Mr. Zangen, in June of 2016 and again in June of 2018, a term expired, which you, actually 18 doesn't matter, because in 2016, the 2-year term expired. It was not renewed. There is no resolution of council reappointing you as a member of as a special magistrate. And based on both the state statute and based on the Wellington Code, since you in fact have not been reappointed by the village council as a special magistrate, you have no authority to hear any hearings, in particular this hearing. And as a result, we object to your hearing this. We object to it going forward. And we obviously believe that anything that occurs here today is invalid.
Understood.
Thank you.
Reply?
Yes. Good morning, Mr. Zhang and Rachel Bosch, Assistant Village Attorney. I'm here on behalf of the Village of Wellington. I would like to respond to Mr. Dom's argument. Our position is that we disagree, and in order to explain why, I'm going to take you back through a little bit of history in terms of the appointing resolutions. Resolution 2012-36, and I have a copy of it for you and for you as well. Was adopted by the Village Council on June 12th, 2012, and by way of that resolution, the Village Council reappointed you, Mr. Zangen, and Mr. Posner, subject to term limits set forth in Ordinance 2012-18. I have a copy of 2012-18 for you as well. And that ordinance, which passed on first reading the same day as the 2012-36 resolution, and let me give you a copy. Thank you. No, I think you gave him both. I'm sorry, Mr. Dom. You got two.
I got two. Oh, I'm
Sorry.
And I don't
And you
have
have
one.
none.
Yes, I need one more.
Sorry about that. So Ordinance 2012-18 passed on first reading the same day as that resolution that appointed you for a 2-year term starting June 12th, 2012. It was adopted on second reading on August 14th, 2012, and that ordinance established an 8-year term limit for special magistrates, allowing them to serve 4 consecutive 2-year terms. The ordinance expressly provided that the term limits were not intended to apply retroactively, and also provided that the special magistrates appointed by the Wellington Council in June of 2012 and beyond, which would include you and Mr. Posner, would be subject to the new term limits. After that, on November 25th, 2014, Wellington's council reappointed Mr. Zangen and Mr. Posner to another 2-year term in adopting Resolution 2014-68. Because the term had expired in June of 2014, the resolution expressly provided that the appointment was retroactive from June 8th, 2014 through June 7th, 2016. June 7th, 2016 is the appointment that Mr. Dom has challenged, but on June 9th, 2015, prior to the expiration of the term that expired in June of 2016, Wellington's council adopted Resolution 2015-43. In adopting Resolution 2015-43, the council changed the method by which special magistrates were reappointed during their maximum 4 consecutive 2-year terms. So pursuant to 2015-43, Wellington Council directed its staff to contact the special magistrates approximately 120 days prior to the expiration of their 2-year terms and inquire as to whether the magistrates wanted to continue to serve. If a magistrate indicated that he did not wish to continue to serve, had already served the maximum of 8 years, or had been removed by Wellington Council for some reason, then staff was directed to advertise a request for letters of interest, to convene a selection committee, and present the 5 highest candidates to the village council for final selection. So in accordance with the procedures outlined in Resolution 2015-43, staff did in fact contact you, Mr. Zangen, and also Mr. Posner in January of 2016 regarding the renewal of a 3rd term, and again in March of 2018 regarding the present term, and both of you indicated, and I have the emails containing those communications, that you wish to continue to serve. Hold on. Mm-hmm. There's 2 of each of those.
So exhibit, let me just interrupt you, Exhibit E, my final term, when does that expire? No? Just so I can make retirement plans.
I believe it expires in June of 2020. I don't have the exact date in June. And here, I think.
That's fine. That's what I figured next year.
Yeah. Is this a new one?
I think so.
E, F, G, Uncle Posner, when he's, and then there's one from.
My point in telling you all of this is that in 2015, council changed the procedure, and Wellington staff followed that procedure in terms of reappointing 2 magistrates who had already been appointed by resolution. And this procedure is consistent with the relevant code provisions and with the relevant Florida statute. Mr. Dom referenced section 162.03, and that section talks about, or gives Wellington's council the ability to appoint a special magistrate in lieu of or in addition to a code enforcement board who can hear violations and impose fines the same way that a code enforcement board would. And in fact, Wellington did adopt such an alternative procedure by way of Resolution 2006-13. And then in the resolutions that I've already provided to you, which is 2012-36 and 2014-68, you were originally appointed. There's nothing in Chapter 162 or elsewhere which prohibits which prohibits a municipality from designating special magistrates, establishing term limits, and then delegating to its staff the authority to renew or extend the appointment up to the maximum term, which is precisely what happened here. The same is true with respect to Ordinance 2-203. You were originally appointed by council, and nothing prohibits council from delegating the reappointment process to someone who's already been appointed by council in the manner that they have.
Anything further?
I'll wait to respond.
Response?
Sure. What 2015-43 did was establish a process by which the village could recruit potentially new special magistrates in the event that the sitting magistrate chose not to be reappointed for whatever reason. It doesn't say anywhere in here that it can delegate the responsibility of reappointing a special magistrate to code compliance. It doesn't say anything anywhere in 2012-18 that a special magistrate can be reappointed by code compliance. The bottom line here is really simple. What they did in 2012 was they established a term limitation of 8 years. And the way they lay it out is very simple. It's 4 consecutive 2-year terms. That means that each 2-year term stands alone. Based on their code, the council has to appoint in a resolution a magistrate and include the compensation for the magistrate within the language of the resolution. It does not allow that to be waived. The statute says that the local governing board may appoint special magistrates. That's what the statute says. And they don't get to ignore the statute by saying, if you look at 2012, Resolution 2012 and 2014 and 2015, and you put them all together and you shuffle them all around, we don't have to have the village council reappoint a magistrate. That's just not the case. The village council must reappoint every 2 years. There are term limits for 8 years of 4 consecutive 2-year terms. Each 2-year term stands alone. Each 2-year term must be renewed. If it is not renewed, you're not a magistrate. And it's just that simple. And that case will probably be filed in circuit court by tomorrow. But I'm telling you here today that based on the law, based on the record, because I did a public records request and I asked for the appointing resolutions for 2016, for 2018, and none exist. And if there is no resolution appointing you as a special magistrate in the village of Wellington, you are not one.
Okay. Motion denied.
Of course. Thank you.
Okay, now, can we move on to the case on the agenda?
I'm going to let Ms. Mitchell make her
Case number
presentation.
NOH 19-129, Palm Beach Polo, Inc.
Deborah Mitchell, Code Compliance Officer with the Village of Wellington. Case number NOH 19-129. Respondent's name is Palm Beach Polo, Inc. Property address is 11630 Polo Club Road, Wellington, Florida. This case was established based on a neighborhood improvement inspection. The NOV-NOH was served by certified mail, return receipt received. Correction date was December 16th, 2018. An inspection on January 3rd, 2019 found the following items remain beyond the time given in the notice in violation of Land Development Regulations, Section 7.3.12.b. Landscaping is not being maintained in a healthy, neat, and orderly appearance, including overgrown grass, weeds, dead and bare areas, and dead fronds. Photos were taken that represent the condition of the property at the time of the various inspections. A follow-up inspection on January 16th, 2019 found the violation still exists. Staff conducted a PACER search, which found the respondent does not have a pending bankruptcy action. Research found there's not a list pendants filed against this property. I have not had any contact with the owner. The Code Compliance Division recommends the respondent be found in violation of Wellington Land Development Regulations, Section 7.3.12.b. It is recommended that the respondent be given until February 3rd, 2019 to correct the violation or be charged a fine not to exceed $250 per day for each day the violation continues to exist. It is also recommended that costs incurred by the Code Compliance Division in the amount of $210.26 be assessed in order to be paid within 30 days of the date of this meeting. Cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and/or the violations are not corrected, it is recommended that a fine certification hearing be held before the special magistrate on February 21st, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida. It is also recommended that no additional notification of the intent to impose a fine be given.
Anything further?
Yes, sir.
Okay.
You can look at this photograph. It's a links course. You can see areas where there's a large rough. You can see areas where it's manicured. We are entitled to manage our golf
sorry,
course.
Is this cross-examination, or are we making argument at this point, Mr. Zangen?
He can rebut. Okay. It's a combination. But
She's made basically in her opening statement. This is my opening statement. Look at the photograph. We are entitled to maintain our golf course in a condition that looks like a golf course, and it does. So we've been down this road 5 times now, 6 times in the last 2 months or 3 months. Our position has not changed. Their position has not changed. We disagree with the validity of this entire proceeding, so it really makes no difference, because you can look at the photographs and you can see there's portions that are maintained, there are portions that are not maintained, there are areas that are rough. Golf courses are not landscape per se, although they will include it in their definition, but a golf course is not landscape. Golf course has rough, it has fairways, it has greens, and those things are maintained differently, and we choose to do so, and we're entitled to do so.
okay. Ms. Mitchell, have you observed any weeds in the roughs?
Yes, this is part of the driving range.
And which course is this?
This is not a course.
It's just the driving range?
It's a driving range that's near the clubhouse.
In Palm Beach Polo?
Yes.
So this is not there's no hole there? It's just strictly the driving range area?
It appears to me to be the driving range. That one, go back one picture. That one picture may be part of the golf course, the dunes course, possibly. Go back another one.
Hey, show me these pictures. Let's go through them and tell me where you see
This one right
weeds. Okay.
This one right here is kind of separated from the driving range, and it flows into part of the golf course. It's a different
Okay.
parcel number. It's still the same parcel number as the driving range.
A different
It's not
parcel.
a parcel
wait.
of the dunes course.
Okay, let me clarify that. Is it a
Okay.
parcel number that the violation is affecting? Because you have one parcel number on this violation.
Yes.
Okay, it
Yes.
belongs to that.
Yes, it belongs to that.
Okay. And let's go through the next picture.
This is along Polo Club Road. That's part of the driving range that's maintained
Okay.
on the left. You can see it's cut, and then they stop right there at that one point,
Okay, towards the right?
towards the right. is
Okay,
what's
and what do we
over.
have towards the right? Is that natural grass, or is that weeds, or a combination?
It's a combination of dead areas,
What have you-
weeds, grass. There's some palm fronds there that are dead, and the palm trees.
Okay, let's go to the next photo.
That's, again, the same location, just down a little bit further.
And what am I looking at there?
That's
That's-
the driving range
And
area.
what is the violation there?
Overgrown grass,
Is it grass, weeds, or,
grass, weeds, dead and bare areas.
okay, next photograph?
That's grass, overgrown grass, weeds, dead and bare areas on Polo Club Road.
Okay, in each photograph you've shown me so far, are there there's dead areas and weed areas?
Yes.
Okay, next photograph?
This is right at the intersection or the corner of Palm Beach Polo Road and Long Meadow Drive. That's looking north to the clubhouse, and the driving range would be towards the clubhouse. That's the dead palm fronds in the picture, grass, weeds, some dead grass in there.
Okay.
Could you point to the, where the dead palm frond is? Because I don't see anything on the ground.
They're hanging off of the
Oh, it's on the
ground.
tree.
They're on the tree.
Ones that are,
Yes,
Tree,
they're
okay,
on the
it's on
tree.
the tree.
Yes.
Okay.
okay, next photograph?
This is along Long Meadow Drive. It's the overgrown grass, weeds, dead areas there.
Okay. And,
This is a continuation to the right of what you were just looking at. That's along Long Meadow Drive. Dead and bare areas, some overgrown grass.
now is
on
this the
edge.
driving range or a hole?
That is,
Looks like there's a pin in the background, I can't see a flag.
I think that's a license, sir.
It's a what?
Zoom in,
I'm
Natalie?
not,
No, I'm talking about that, there's a little red back there, always in the back. See, a little red, like, looks like a red flag? Is that a hole, or is that a driving range?
Let's see.
I believe that's part of the driving range that's being operable. That
Okay.
they're shooting, hitting the balls to.
Move over a little more to the right. Yeah, see that?
That's
It's-
part of the driving range.
Okay. Well, Ms. Mitchell, what's your understanding of that?
Between where you're looking at right here on Long Meadow Drive towards the clubhouse, I don't know the percentage of it, but a portion of it is maintained as a driving range. There's people out there hitting golf balls from the clubhouse looking towards where I'm standing, but another portion is not being maintained, and that's to the left. And then this area here, beyond the grass and in front of where I'm standing is all dead grass. I mean, it's dirt.
All right. There any more photographs?
Yes. That is to the right of on Long Meadow Drive as well.
All right. And where are we looking at there?
What picture is that? Is that back to the beginning?
No, I don't think I've seen that before.
What number is it?
Yeah, you took that picture yesterday, Deb.
I took that picture
It's
yesterday.
it's dated yesterday. Do you know where that is?
That would be along Palm Beach Polo Road.
All right.
And
And
that's along Palm Beach Polo Road. You see the structure in the back is along Long Meadow Drive.
and what is that, that area there?
That's,
How would you describe it?
that's part of that parcel.
And what am I looking at? Grass,
That's-
weeds, mixture?
That's grass, overgrown grass, weeds.
All right.
Yeah. Beyond that, you can see the grass is maintained,
Mm-hmm.
and that was a close-up of what you're looking at there. You see where it kind of mounds up there, goes up at a slope up? That's where I was
Mhm.
standing over there, and I was a little bit closer to it. I zoomed in, so you could see the level of the grass and the weeds.
Is that you back there, Mr. Dom, sitting on the car?
Probably not.
Okay. All right. Is that the, wait, go back to the last picture. Is that the driving range or a hole?
That is just to the right of where the next picture she just went to. That's where the driving range maintenance, the grass is stopped, and then it's not maintained here.
Okay.
And go to that next picture, Natalie. That was just a close-up of what that is right there.
All right. Any more pictures?
No, that's
Okay. Anything else you need to add?
no, sir.
So your testimony is what, overgrown grass and,
Overgrown grass, weeds, dead fronds, dead and bare areas
okay.
at that parcel number.
Mr. Dom, you have any questions of her and the witnesses?
No.
Okay. Here's my question to you. What constitutes a link golf course? Besides just calling it a link golf course?
The PGA rules. There are a number of other definitions out there that refer to links course and links-like courses. Obviously, we're not along water, but we are still entitled to grow the grass. We are entitled to configure our golf course in a manner consistent with the extended rough or the larger roughs that are associated with links-type courses. It's all through Scotland, Ireland, a lot of courses in the United States. It may not be pleasing to the eye for some, while for others it is. And so we are trying to reconfigure courses all the time. The other course was redone last summer and is open and is being played and is manicured. We're going for a different effect. We've done that over at Polo West, where we have created kind of a target golf environment. That course opened in November and is operating, and we've had some play. So I don't think it appropriate for the Village of Wellington to take their generic landscape ordinance 7.3.12B, which generally would be for residential and commercial developments, and say, ooh, you're letting the grass grow too long. And yes, if you let it grow, there might be some species of weed, shall we say, which Mr. Flincham is here to tell you all about. But so what? We're growing it for a reason. We can contour it for a reason. We can turn it into something different if we so choose. This regulation is intrusive and excessive into our right to configure our golf courses in a manner which suits us and which does no harm to anyone. And that's why we're here. So we think this is harassment. We think that Ms. Mitchell's job is to basically cruise around Palm Beach Polo at least every day and see what she can find and write it up, which is why we're here every month and why we appeal all of these and why we take these to court, because it's just all excessive. So if you look at some of these pictures, you can see some of the grass is perfectly maintained for golf purposes, and there's a rough around it, and those things are going to continue because we need to be able to do the things we need to do to redo our golf courses as long as we're not bothering anybody. And if the people at Palm Beach Polo call and complain, they go out, we come back here. But we're still going to work on our golf courses and do the things that we need to do. Not that it matters here, because again, this particular proceeding has no validity anyhow.
Ms. Mitchell, let me just ask you, I'll give you a chance to rebut.
Thank you.
As There been complaints, or are you this proactive? This
I
particular
believe that
case.
Steve has gotten complaints on it before. But when I saw it being overgrown, I gave them a notice to cut the grass, maintain it. But I haven't gotten any phone calls personally on this.
Okay.
But I believe our office has gotten phone calls on this. But we tell them we've already got a case on it.
All right. You have any response?
Just briefly, I want to respond to Mr. Dom's argument that 7.3.12 somehow doesn't apply to golf courses. Mr. Dom hasn't pointed to anything in the code that would exempt them from that provision. That provision is not specific to residential areas. And in fact, this argument has been made before this tribunal on 2 occasions relating to links courses and 1 relating to target golf, and it has been rejected on all 3 occasions. I have copies of those orders if you would like to review them. There's also been no evidence that any effort has been made to communicate with the village about whatever these efforts are to try to work something out so that possibly this redesign could occur without violating the code.
Mr. Dom, you said this is a link course pursuant to the PGA?
It can be.
Do you
if given an
have anything
opportunity.
from the PGA saying that this course is a link course?
Well, the PGA is not going to say, poof, you're a links course, okay? What they do is they define certain terms, and they define certain layouts and certain things you can and can't do and can have in order to be a regulation course. And the rest of that is up to designers. But it's kind of, I used this analogy yesterday in a meeting about this, and it's kind of like a bad haircut. You kind of have to let it grow out in order to fix it. We're letting it grow out so that we can redesign it into something that would be aesthetically pleasing to the community and still workable and functional for my client, in light of the fact that golf is not a hot commodity at the moment. We have 2 18-hole golf courses within the club, plus another 9 holes in the Old North course that have been dormant for years, and not many players left. And so the cost of maintaining the specific level of grass, the kind of 409 and other specific kinds of grass, at the 1-inch level and fairway level and at the green level is expensive. The water from the South Florida Water Management District that monitors every ounce we use through our pumps is expensive. And as a result, we have to accommodate both. We have to try and make it more economical and still make it kind of user-friendly and playable. And that's the process that we're involved in at the moment. And yes, I was told yesterday, we can do this, but we have to come in with some kind of a plan and show where the rough will be, where the greens will be, where this and that will be. But that's the first conversation we've had about it. And in all the years my client has owned and operated golf courses in Wellington, he has never been told that he had to come in with a plan. When he bought Polo West that was dead for a while and reconfigured it, he reopened it. The course's tee boxes move, holes move, certain things change. Hazards get built, changed, cart paths get moved. It happens all the time. And Wellington has never said, oh, you need a plan, you need a permit, you need this, you need to do that. It's never happened until now. And in the last 5 months, we've gotten hit on cut the grass on every golf course and every piece of property we own when we're trying to implement a particular plan. So Now we know that we need to submit some kind of a plan. We will work with the village towards trying to come up with a particular plan, but that doesn't necessarily mean that we're going to have to cut everything back 6 inches to 6 inches to appease them, because we're still entitled to build out the course the way we see fit.
My understanding of, I'm not an expert in, of link golf courses, obviously they do have thick roughs, but they're natural grass, not weeds. Unfortunately, what I've seen in the photographs are a lot of weeds, and you know, if you have dirt in somebody's hair, they get a bad haircut, you get rid of the dirt. You can't allow the weeds to grow and say, I'm making a link golf course. And just by saying it's a link golf course doesn't make it a link golf course. There are certain criterias that I understand, but nobody introduced that, so, but they do have thick roughs. I agree with you. They do have, but they have natural grass, not weeds. And what I see from the photographs is whatever you call it, whatever type of golf course you're calling it, I see weeds. And 7.3.12.b applies to golf courses. And it's not being maintained in a healthy, neat, and orderly appearance. And I'm not talking about cutting it, but I'm talking about weeds and dead patches. So I understand your position. You know, you think this whole hearing is not proper and is illegal. That's fine. You can do what you need to do. What I'm going to do is, unless you have anything further to say, which I don't recommend you do, but I'm going to take it, I'm going to write an opinion on this, and, but basically, I'm going to find your client in violation. Okay?
Stunned.
You knew that was coming.
Stunned.
I know you were. Thank you for your comments. I appreciate it. Well done. You both argued a great job this morning, but here we are, back in circuit court.
Mm-hmm. You bet.
Thank you, Mr. Zangen.
This is a great annuity for you.
It's not nice.
Off the record.
I don't think it was. Okay. Thank you.
It was.
Thank you, sir.
All right. Anything further?
That concludes the agenda, sir.
Okay. Okay, this hearing is concluded. Thank you all.